To go to the replying papers where there has been additional points raised, and it's in volume 7, milady. The participation complaint is made so nebulously and is not pleaded. The court doesn't know whether the complaint is directed at province or city or both. So the suggestion is made that this somehow concerns Section 38, and that's, as I've said, is not a matter which concerns the city. But I need to deal with it just in case the court considers that participation is something the city needs to answer. So let's deal with what the applicants understood as relevant in relation to Section 38 and participation. And that's at page 2610. So here there's a quote of what Section 38.3 says. And and if one just if I can ask your ladyship to turn over the page and then go back to page 2610, there are the various paragraphs A to G. And I'll ask your ladyship to note which are underlined, which are relevant ones to the reply. It's A and B. And what's significant about this is what's not underlined. The applicants don't say, look at E. They don't ask the court to place emphasis on the results of consultations with communities because it's not relevant to the case. It's not relevant to their case. It's not relevant to this matter. In 39, they say the effect of A and B, 38.3A and B, is to stipulate that the heritage impact assessment must provide, at a minimum, provide a systematic inventory, including graphic representation. And then 40, they say, the purpose of this component of a heritage impact assessment, that's A and B, is to provide a complete objective picture of heritage resources that would be affected by the development proposals and how they are stated. It also serves to inform the inquiries contemplated in C, E, that's the results of consultation, F and G, viz. Assessment of the impacts of development proposals on heritage and relative social and economic benefits, possible alternatives, and proposed mitigations. So, in 41, without an objective identification, appraisal, and mapping of heritage resources, and then it continues. The concern there is about the content of the HIA. That was their complaint. They said it didn't meet the information in the finding papers requests, and then it morphs into alleged requirement. That's the complaint in the reply directed at province. But they don't say that there was any problem with E. There's this allegation, which was the subject of a striking out application, that the developer failed to comply with the information requirements. They say it's obvious that the developer had failed to comply. And in disregarding the request in this interim comment to submit a supplementary report. So they alleged the failure to comply. And then they say they don't understand that the minister or Mr. Africhting to contend that the AFMAS report was a supplementary report. So they say that the objection here is a failure to provide a supplementary report, and then they go on to say in detail why the AFMAS report was not a supplementary report. And then paragraph 52, again subject to a strikeout application, but for this purpose it's useful to see all the criticisms of the AFMAS report. Here they say, and it goes on for quite a long a list of all the complaints about the AFMAS report. And just to highlight the point about this list is what's not here. There's no complaint that there was an exclusion. The complaints are, one, failure to undertake appraisal of heritage resources. 2, there's an aspiration, or it seeks primarily to ascertain the aspirations of the First Nations informants. 3, it does not record the identities of the participants or provide a record of the consultations. 4, impartiality. 5, methodology. And then 6 refers to another affidavit. And then 54, on page 2618, concludes saying that the developer has manifestly failed to comply with the HWC's information requirements. No complaint about participation. The defects in the NEMA decisions. The facts and circumstances set out above demonstrate substantial and material defects in the heritage assessments and the Section 38.8 process. Patently, HWC's information requirements were not complied with. Accordingly, on the Minister's own construction of his powers, the jurisdictional fact necessary for the Minister to grant environmental authorization was absent. Our learned friend for the province has shown you that that's not true, but the point from the present purpose is that's the complaint in the reply is in relation to information requirements. And then 65, an allegation of usurpation of the exclusive jurisdiction of HWC. That complaint's fallen away. And then lastly, 66, reasonableness and rationality. Again, no complaint about participation. And then the next section, from 68, deals with the complaint against the city. And it's in paragraph 68, there are three grounds of review set out. And that is what I summarized in the table earlier on. And the complaint is that a proposal before the HWC to formally grade the river site was not considered. Number 2, provisional protection notice is in place. So this is the replying affidavit in which the applicants summarize their review grounds. And we've dealt with the provincial review grounds, no complaint about participation there. And then from paragraph 68, the summary of the review grounds against the city. 3 review grounds. 1, the failure to consider that HWC, there's a proposal to formally grade the site. 68.2, provisional protection notice, and 68.3, policy. And again, it's what's not there that matters. There's no complaint about a lack of participation. In the mind map, there's a reference to the applicant's heads of argument. I'm not going to take your ladyship there. The paragraphs are there, paragraphs 92 to 122. That concerns the province. These are the heads of argument which were filed by the applicants. There's no suggestion that participation was a potential review grant or an issue. And then in relation to the city, paragraphs 123 to 138. So again, if the applicants were concerned about participation or thought it was an issue, they would have said so. It wasn't. It wasn't an issue because there was adequate participation, more than adequate participation. On their understanding of the matter, there was adequate participation. There are 2 submissions made in the oral argument. The first is a claim that membership of the FNC is a precondition for participation. So this is the first of the complaints about participation, is that there's a reference to the statement in the AFMAS report where he says Mr. Arends has said that the position taken by the collective and invited the Goring High Corner to participate and join the collective, cautioning that the Goring High Corner that refusing to formally engage would constitute a voluntary extraction from the consultation process akin to self-imposed exile. So, and the submission is made. It is clear from this extract that it was a precondition for consultation that the Goring High Corner joined the First Nations collective. Lady, that's wrong. It's wrong, wrong, wrong. The AFMAS process was one element in a very long consultation process. And there's the point that your ladyship is alive to, and that's that the applicants, second applicant in particular, had the opportunity to participate in the AFMAS process, initially did participate and withdrew. But it's wrong to say that their non-participation either in the FNC or in the AFMAS process in any way excluded them from the consultation process, which was a process not before Mr. Aronson. He wasn't the decision maker. He wasn't even the specialist in the environmental authorization. In fact, he wasn't even the EAP. The decision maker in the environmental process was the director and the minister. The decision makers in the planning process were the MPT and the mayor. If the second applicant excluded themselves from the FNC, that had nothing to do with their ability to participate in the decision-making process, which was a process involving the decision makers. So the question your ladyship is confronted with would be relevant. Again, only if your ladyship considers this matter something to be decided, and your ladyship would not get to this because it's not something raised on the papers. But if the court were to be concerned about this, the issue would be, well, was there exclusion of the second applicant in any of the decision-making processes? So let's see what the evidence is, not by the respondents, but by the second applicant themselves. And that in volume 2 is at page 742. So this is Mr. Jenkins speaking in his affidavit, in which he says the Goran Haikona Khoi Indigenous Council has consistently opposed the proposed development and have taken a number of steps in an attempt to ensure that the heritage associated with the site is protected for current and future generations. These steps include, and then there is the 9 subparagraphs. So this is what the second applicant did in the process and was allowed to do and was involved in. 1, it supported the application for the provisional protection of the site by HWC. 2, participating in an appeals tribunal hearing concerning the validity of that protection order. 3, applying to HWC for the site to be granted, to be graded as a provincial heritage site, grade 2, and making representations at the HWC hearings. 4, applying to SARA for the site to be graded as a national heritage site, grade 1. 5, submitting representations as an interested and effective party during the environmental impact assessment process. 6, submitting an appeal against the granting of an environmental authorization for the proposed development. 7, submitting objections in relation to the application for land use planning approvals for the proposed project. 8, submitting an appeal against the granting of the land use planning for the proposed project. And 9, making presentations to the Planning Appeals Advisory Panel. There are things which he doesn't mention. He made written submissions as well. But these are 9 aspects in which the second applicant participated in their own words. This is extensive participation. There's nothing following this that says, well, that wasn't enough. We didn't have an opportunity. We were excluded. This wasn't early enough. There's no complaint like that. There is no case that I know of and which the applicants can or will refer you to, either in South African law, foreign law, or international law, in which a court has successfully upheld a complaint about exclusion by a person who participated. It's not possible to reconcile those two concepts. I was excluded, but I participated. The fact that the second applicant did participate is the reason why they never complained about some sort of exclusion from the process. So that's as simple as one needs to consider this point. They participated fully. They had an opportunity to make whatever representations. They were represented by lawyers in the process, lady. In fact, Mr. Bishop's attorneys, the LRC, represented the second applicant in the city's process. I did my articles at the LRC. They are experts in representing and have a very long history in our country of representing indigent communities who in some way struggle to express their interests in a way which can be appreciated in complex legal processes. And so they had sophisticated, adequate expert representation. It was full and complete participation, early enough, fully compliant with whatever principles exist in national law and international law. So that disposes of the issue about membership of the FNC being some sort of precondition to participation. It wasn't. There was the opportunity to speak to the decision makers directly, which the second applicant and anyone else, the second applicant did, and anyone else either did or could have done. Your ladyship asked a question. Lady, the second submission that I wish to deal with that was made in the oral argument is on the question of exclusions, alleged exclusions. And it was both made in the written note and in oral submissions to your ladyship. First, the written note. Please would the court turn to page 43. Our learned friends for the applicant say, it is also important to note the extent of the First Nation groupings that were excluded. Does your ladyship have that?
Yes, I do. 107.
All right.
Yes.
Now, what matters is that submission, the allegation that there were exclusions and that there is some sort of extent of exclusions. And then the next sentence, these are listed at paragraph 78 on pages 740 and 741 of volume 2 of the affidavit of Ms. Jenkins.
I see the
Can I
list
ask
here.
the court to hold that page
Yes.
open, 740? Does your ladyship have that?
I have the page here with the list, yes.
All right. Now look back at 107. This is the extent of First National groupings that were excluded, and the court has referred to page 740. And at page 740, it's paragraph 78.1, and it continues over the page, and there's a list of groupings.
Yes.
So in the written note, it said these are the exclusions, and then this was repeated in oral submissions. Your ladyship said, well, where is the evidence of exclusions? And my learned friend took your ladyship to page 740 and said, look at the list. Those are the exclusions. My lady, that's wrong. That is wrong. It's misleading. Look at the previous page. The one that you not referred to. It's what paragraph 78 is about. Paragraph 78 says the following. Despite the narrative disseminated by the FNC, the leaders of the vast majority of First Nations organizations have confirmed in their conversations with me that they remain strongly opposed to the proposed development.
Where are you reading from now?
I'm reading from the previous page. So
Page?
you were referred to page 740,
Yes,
and if one turns
so I must go back, right?
one page,
Yes.
paragraph 78, does your ladyship have that?
Yes, I do.
Despite the narrative disseminated by the FNC, the leaders of the vast majority of First Nations organizations have confirmed in their conversations with me that they remain strongly opposed to the development. If your ladyship can circle the word opposed. Of these traditional authorities and organizations, this is over the page, this is the part that your ladyship was
Yes.
referred to. Of these traditional authorities and organizations, the views and ethics engaged in this process as a violation of the SAN ethics. These include, and then there's the list. So what is it a list of? It's a list of allegedly, the allegation is that these organizations oppose the development. They oppose the development. There is nothing suggesting that these groupings were excluded. What do those lists represent? What's common to them? Why is the court being referred to this list? In oral argument, it was said that these are the organizations that were excluded. But that misrepresents the evidence. The evidence is that these are the organizations who oppose the development. Those are very different things. In fact, how does one oppose the development if one doesn't know about the development? If one knows about the development, one knows about all the opportunities to make representations. It proves the opposite of exclusion.
Is 78.1 and those mentioned in 78.3, are we dealing with the same groups? I'm just trying to establish that. I don't want to get confused now. In other words, those who participated and opposed, are we dealing with the same groups in 78.3? Those mentioned in 78.1? Is it the same group as 78.3?
I haven't done the analysis, milady.
It doesn't appear to be the same. That's why I'm asking.
Yeah, I can't answer your ladyship's question off the bat.
What does the city say with regard to the exclusion of those mentioned in 78.3?
What does 78, what does the city say about?
The exclusion of those mentioned under 78.3, is that not correct?
No one was excluded,
I
milady.
see.
Nobody was excluded. Everyone was invited to participate, and they either did or had the opportunity to do so. And some supported the development, and some organizations opposed the development. The allegation made by Mr. Jenkins is that these are the organizations that opposed the development. He is not saying these people were excluded.
Oh, I see.
Does your ladyship have
I see what you're saying.
That's
There's the heading and then the subsections.
The subsections to what?
To those who participated.
Well, he
Or
doesn't say
opposed
they
for that
participated,
matter.
but he says they're opposed.
Yeah.
He doesn't deal with participation because it wasn't an issue that the applicants brought to court. He's saying, look, I'm not alone in objecting to development. There are other people who also object.
I see.
There's a long list of people who object.
By implication, they are actually included in the
They must be. That's the only inference one can draw from that. Is
They
that
were included.
They were participating. Indeed. It's certainly no basis for the submission by my learned friend that these people were excluded. That's simply a misrepresentation of the evidence. In fact, there is not one allegation of exclusion in the affidavits. So your ladyship can put that question on the facts out of the court's concern about the processes involved.
So this would then encompass those opposed to the project under
Allegedly,
78.
milady, yes. Yeah. I don't have a comment on whether they in fact opposed
Because
or not.
it's a large
hearsay
group, that's why I'm
allegation.
asking.
Sorry?
It's a large group, that's why I'm asking.
Apparently, milady, I don't have submissions on that. I can't say whether these groups overlap, how many they comprise. There's an allegation by the FNC that they represent the majority of Khoi and San groups. The city's position in relation to these competing claims for representativity is that the city doesn't need to resolve that, doesn't need to say the people and the supporters outweigh the objectors or the other way around. The city's approach was to say, I'm going to listen to all the submissions. It's not about saying, well, the city can't and the province can't exercise its statutory powers by holding a referendum on its decisions which it needs to make and then saying, well, the public must decide. It's a decision which must be taken in terms of the relevant considerations in the statute, and the views of the communities are important. But if there's extensive opposition for good reasons, those reasons must be considered. And as I've said, the second applicant's concerns were referred to 40 times in the city's reasons. And what Mr. Jenkins is saying in 78 is that his views also represent the views of all of these other people. So all of those views, whether they're a large number or however many people they are, were all properly considered. And that's the relevance of that for this court in considering potential review ground.
He said he had discussions with him. Let me see the words that he used. They confirmed in conversations with me.
That's Mr. Jenkins
Yes.
saying that he spoke to these groups.
Yeah, these groups, yeah.
So that's hearsay evidence because those groups don't come along and say we're co-applicants or we confirm that.
Yeah, I think the applicant can clarify that in reply. Yes.
Well, the point that Kamau asked your court to direct this question to the applicants in reply is where in the papers do they allege that anybody was excluded? It's not 78. That doesn't say that anyone was excluded.
Yeah.
Where else is there an allegation of exclusion?
Well, it appears that those mentioned in 78 were aware of the project
Indeed.
because they discussed it, because during their conversations with him, he then established
Yes.
that they opposed the project.
Yes.
So, by implication, they were aware of it,
Yes.
they were consulted, and they expressed their view.
Yes. And they expressed their view to Mr. Jenkins, who
Yes.
represents the second applicant. And Mr. Jenkins has told us in his paragraph 80 how extensively he was involved. And any one of these other groups, either represented by Mr. Jenkins and the second applicant, or themselves could have also been extensively involved. The complaint made in the oral argument, which is impermissible, but the complaint is a complaint about lack of participation. It's not that there were lots of people opposed to it. That the applicants obviously accept is not a basis for review. The complaint here is exclusion, and there's no evidence for that, so the court doesn't need to concern itself with.
The applicant said here in paragraph 79 that he will obtain supporting affidavits in the review proceedings. He will. That's what he says in 79.
Yes, and that would be support
For
of
the
their
review.
opposition to
Yeah.
the development, not support of any complaint about participation. That's the only evidence here. Is there's opposition, and we're going to get support in the form of affidavits. The last point. So this leg of the argument in relation to consultation is that the case wasn't pleaded. The claims in the oral argument are unfounded and not supported by the evidence. In fact, they're contradicted by the evidence. And so there's no case before this court of any problem with participation. The city did provide heads in response to the amicus, and the city focused on if I may refer your ladyship to those heads. So and I'm not going to take your ladyship through this, but
Yes.
what we do at paragraph 27, which goes over a number of pages and various subparagraphs, is in response to the hypothetical contention by the amicus that if there was no participation, then various principles in international law might apply, is the city sought to just say, well, it's not an issue because on the facts there was such extensive consultation that the review court would never get to a question of saying, how do we apply international law? So what the city did is did an exercise which it was difficult to do because it wasn't an issue raised in the papers, but just sought to say, look, here is what happened in relation to consultation. And and I'm not going to take your ladyship through it because it's not relevant for the court to look at the question of participation, but there are 27 subparagraphs, 21 subparagraphs.
Where are you now?
Going back over years and it echoes paragraph 80 of Mr. Jenkins where he said they participated in all these various respects, and what your ladyship can match that up with this more extensive list of participation opportunities.
Where are you reading from now?
I'm reading I'm referring to paragraph 27 of the city's second heads in response to the amicus, where the city says that there was adequate and effective public participation in the decision-making process.
Yes.
So paragraph 27 goes over a number of pages. It has
I see,
subparagraphs. There are 21 subparagraphs. I'm not going to take the court through them. They have references in the footnotes to the record showing where the evidence is, and it's all uncontested evidence about the various consultation and participation steps that we have available on the papers, despite the fact that participation wasn't even raised as an issue. One can still scrabble through affidavits, and my junior did the tedious exercise of trying to find all of this evidence, despite the fact that it wasn't actually pleaded. And one sees all of these opportunities, and it's more succinctly summarized by Mr. Jenkins, where he said, this is how he participated, or his organization. And if one goes to on page 17, subparagraph 13, there's a reference to the AFMAS report.
Yes, I see.
And that's the first, so what happened is there was an initial participation process, statutory participation process. Heritage Western Cape wasn't satisfied with the adequacy of that and said to the developer, engage further. Mr. Arendse was contracted to have a more participative, engaging participation process, and that then fed back into the formal HRA process, which then fed into the NEMA review and was considered by the city. Paragraph 20, just going towards the end, there was a final BAR, that's the report in the environmental process, and there were multiple phases of public comment, 494 comments from the general public. The second applicant and the first applicant were both among the commenters on the BAR. Mr. Jenkins specifically mentions that in his list in paragraph 80. So that was participation. And then in relation to the planning decisions, the last paragraph, and this is, we deal in one of the paragraphs, so the last paragraph, sub 21, is one paragraph in which we deal with all of the participation by the city, but that was 4 opportunities. There was written submissions to the MPT, oral submissions to the MPT, written submissions on appeal, and oral submissions on appeal. And so those were multiple opportunities which extended beyond the requirements of the statute. So that list then factually disposes of any complaint of non-participation or lack of participation. And as your ladyship has observed, there will be still further opportunities in relation to the specific commemoration features in condition 21 of the city's conditions. So even though the decision's been made, the consultation will still continue. Lady, that concludes the submissions on participation and on the notion of the question of whether there's a right to review and the prima facie right and the requisites for an interdict. So for all of those reasons, we submit that the court must refuse an interdict. So it's the last leg of the mind map. And your ladyship will be concerned with how to apply BioWatch in this matter. That's the case on which the applicants say they should not be asked to pay the costs of the respondents, or at least the state respondents, should they lose the interdict application. And so one needs to look at the authorities on how to apply BioWatch. So there's a constitutional court case in Harilal, 2018, the citations in the mind map, and the court deals with the exceptions to the BioWatch principle. So the general rule is that a losing private litigant does not pay the state's costs. but there are exceptions. And among the exceptions is if the litigation is instituted without sufficient ground or without probable cause. That's the test. Litigation instituted without sufficient ground or without probable cause. And the Constitutional Court relied on its previous decision in Lawyers for Human Rights, which is the citations given. So where someone comes along and waives the Constitution and says this is constitutional litigation, but in fact there's no substance to their case, then they must pay the costs. Biowatch doesn't protect them. And that principle has been applied by the SCA in the Burghardt matter, a planning matter as well. Your Ladyship will be familiar with that. It's been dealt with in a number of cases which your Ladyship has considered. Paragraph 86 of that case, the Supreme Court of Appeal, a unanimous decision, says, as has been stated by this court in National Home Builders Council, the mere labeling of litigation as constitutional is insufficient. For the Biowatch principle to apply, the case should raise genuine, substantive constitutional considerations. The rule does not mean risk-free asserted constitutional litigation. That case involved the Burghardt community saying that the building erected next to so Burghardt is in fact a protected heritage site. I think it might be a national heritage site. So it has heritage protection, formal heritage protection under the law, unlike the River Club site. And it was a very controversial development. The city's heritage department opposed it. Heritage Western Cape opposed it on heritage grounds. The applicants brought a case against the planning approval on heritage grounds. They said our constitutional right to culture and heritage is violated by this building. The court looked at the case and dismissed it and said, no, there's no substance to your case. The objectors appealed to the Supreme Court of Appeal. The Supreme Court of Appeal said there's no substance. And on the question of costs, ordered the objectors to pay the costs because there was no substance to their case. So in this matter, in the Burghardt matter, if one reads the judgment, there were a whole lot of arguments about heritage, about what effect the building would have on heritage, would it be imposing, would it kind of destroy the sense of place of Burghardt. There was something to argue about. Here, there's nothing to argue about in relation to the effect of the development on heritage because the unanimous evidence, the consistent evidence is that the development will only help heritage. And on the review grounds against the city, the case has manifestly collapsed. There is simply no case. The applicants don't even suggest that the one thing that they raise, the Upmust report, is in any way a review ground. So this is quintessentially an exception to Biowatch. The applicants initiated, and they persisted, even after the answering papers were filed, with the interdict in respect to the city's decision without sufficient ground and without probable cause. And for that reason, we say that they must pay the costs of the city, including to council. Those are the city submissions, milady.